typically wait until like 10 o'clock. It's not go, you know,
Yeah.
walk out starts early, but I'll be objections.
Yeah.
Correct. Full justice.
Feel free to make as much noise you want when I'm talking. That'll distract me. Everything will be good.
I'm supposed to know that. Said number 2, cancel. And then we're number 3. I think.
There's 2 10 o'clocks. We're first listed at 10 o'clock.
Yeah, the first one's State Farm.
Yep.
Deputy McClendon.
There
There we go.
So we should get set up. So,
Yeah, they do that. They'll put the 10 to 10. I think it's so that everybody's here.
Which makes sense, because they told me 10:30, I'm like, I'm here till 10:30.
Right.
you like the new? You should see the trial.
Is that what you're trying to say?
Yeah, I don't know, because it's on my folder, my witness folders. There's jury instructions open, request for revisions are all witness, when DV closing and appeals my last one. But as the trial progresses, there's nothing on those cards. Not now. That's for when don't talk.
Ryan messed this up,
No,
this up,
no.
this up.
And they just, which is maybe nicer than the second. I wish they'd have written, that'd have been a nice opinion.
That would have been pretty hot to the PCA. Pretty happy with the PCA.
What is Scott say? They watch.
He watched it.
And what is it?
He couldn't watch it at the time, he watched it later, and he goes, yeah, you don't get a chance to answer any questions, so I don't know if it matters what you say.
He started. Yeah, gosh. Oh, well.
I think this could be taken together.
So,
It's, tell him that.
how about, I'm working on that yesterday. I was finishing up, finishing the
I
first
thought they were
one.
negotiating some, like,
No.
Would you like an extra one of those?
I do.
Can I have it?
I've got a couple as well, Bill, I'm sure.
We've not gotten that big always, and that's just ridiculous.
Are they using, what is that big?
I don't know. My lawyers, looking those up, and then, Feltus is what, no, what's the day, Thursday, so Tuesday. I'll finish the first draft of Feltus this afternoon, and hopefully finalize that.
At least we made an issue of it, right?
I'm trying to think now, it's been 2 days.
I can't remember what the issue is, but I remember looking at it and what we were asked to do, and I was like,
No. So, was it constant repeated? Or did you didn't do that one?
we did customer courtesy, we generally engage based on, was it Jarenko's testimony?
Yeah, but it's gotta be
Something else.
let's say, but what if one page is?
All rise.
2 years of presiding.
Appeal on Hidden Floor, the 5th District of the State of Florida is now in session. The Honorable John M. Harris, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to oral argument session here at the 5th District Court. As Marshall said, I am Judge John Harris, joined on the panel today by Judge Brian Lambert and Judge Joe Boatwright. Got 3 more cases today on the docket. Each side has 20 minutes to present their argument. Appellate can reserve as much of that 20 minutes as you would like. The default is 5 minutes. If you would like something other than that, please just let me know. If you have any cell phones or other noise-making devices on you, please make sure those are silenced at this time so the proceedings are not interrupted. And just a reminder that the hearings today are being recorded and live streamed on YouTube. All right, our next case is 23-459 State Farm versus McClendon. Counsel for appellant, if you are ready, you may proceed.
Good morning. May it please the court. My name is Ryan Jones, and I represent State Farm Florida Insurance Company. I'll reserve the standard 5 minutes for rebuttal if that pleases the court.
Thank you.
I think the court's aware that we have this same issue on appeal in a handful of different cases. I want to start today by addressing an issue that wasn't quite as clear as it could have been in some of the other arguments. That is, a decision in favor of State Farm does not preclude the insured from recovering the tear-out costs. All the insured would have to do is enter into a contract that satisfies the requirements of the policy and Florida law. And that's what State Farm is requesting in this appeal today.
Why does the contract here not satisfy State Farm?
The contract doesn't satisfy it because the requirement under the policy is that the cost must actually be incurred before the payment is due. And I'm getting that from the Florida Supreme Court's Zavallo decision. The contract in our case has a clause that allows the insured to void the contract up until the point that State Farm's
But only if the insured doesn't pay, correct?
Only if the insurance company doesn't pay.
Oh, sorry, the insurance company doesn't pay. So really State Farm has the ability to control that contract then, correct?
I'd say that State Farm has the ability to control the check, Your Honor, but the actual control of the contract is done by APT. That's who wrote the contract. So if APT did not want that, what I'll call a contingency in there, it simply could have written the contract differently to not include that. The reason that's such a concern is that up until the point that State Farm issues the payment, the insured has the ability to void the contract, essentially to escape liability. And under Florida law, the point at which liability attaches is the point at which an expense is considered incurred.
Why does State Farm care what Miss McClendon does with the money? I mean, it's a covered claim. You went through the appraisal. You guys compelled the appraisal. The appraiser came back and said this. Miss McClendon said, good number, or she said, well, that's the number. There we go. And you guys said that's fine. If Miss McClendon goes and spends the money on lottery tickets or fixes the place up or does, pays for her kids' college, what does that matter to State Farm? At this point, she's paid premiums all these years or whatever.
Under the base coverage of the policy, Your Honor, there is not a restriction on how the insured spends the money, and that's the coverage for the direct physical loss. But the coverage that we're dealing with, tear-out coverage, is an additional coverage. It's something, as the Florida Supreme Court described it, above and beyond the base coverage. And what's important about it is that the language of that additional policy, of the additional coverage, says that it is a cost incurred by the insured. And the whole purpose behind that is to ensure that the work is actually done, as opposed to the insured saving it or buying lottery tickets or using it for any other purpose they choose.
And I'm not suggesting she would do any of those. That was just a hypothetical.
Oh, certainly, Your Honor. And it is just that's the reason for that type of a provision, is to ensure that the property is repaired.
So what's your interpretation of when you actually incur the costs? When does that happen?
Judge, that was addressed in the second DCA's Brewer decision, and what the case states is that when liability attaches, that's when a cost is incurred. And
So what do you mean by that?
when liability attaches, when there's nothing else to be done in the contract. And Brewer provides a real good example of that.
So when she pays for those costs?
She could do it a number of different ways, I believe, if the work begins or if she writes the check for the cost. But the contract...
Why not just specify that in the provision clearly then?
Well, the provision I'd submit, Your Honor, does specify clearly that the cost must be incurred. It's Florida law that interprets that phrase incurred to mean become liable for. And at the point which liability attaches, I think it's a fair reading of that case law to say the point at which liability attaches means there are no more contingencies left in the contract. There's no escape clause or out, for lack of a better word, for the insured. And that's why the APT contract...
So are you talking about the Sabalo case?
The Sabalo case is the one that defines incurred. The Boer case is the one that says liability attached.
Well, doesn't Sabalo, towards the end of the case, it says Citizens Counsel conceded an oral argument that to incur means to become liable for the expense, but not necessarily to have actually expended it, and then the Supreme Court said we agree.
Correct.
So she wouldn't have to actually pay for it under the Supreme Court's ruling in that case, correct?
That's exactly right.
Okay, but you had just told me before you mean incur means to have to pay. That's one of the things you look for is whether they paid it or not.
If I use the word payment, I must have misspoke, Your Honor, and I apologize. The incurring is to become liable for. The point at which liability attaches is when the expense is incurred. And in this case, our position is that liability has not yet attached because under the APT contract, the insured can still void it up to the point that State Farm issues the payment. So as we stand here right now today, State Farm has not issued the payment, and if this court finds in favor of State Farm, the insured would not be liable to APT because she has the option to void the contract.
So what would she have to do? Okay, let's say it was $120,000 instead of $12,000. And let's say she, like most people, doesn't have $120,000 to just pay it out of pocket. She would have to enter in a contract with APT saying, I contract with you to go do this repair work and I'll pay you $120,000, end of discussion, and then they show up and start working. I'm trying to envision what it is other than her actually, here's your money.
So
how it becomes incurred under State Farm's view of the policy.
She would have to enter into a contract that imposes liability. And what I mean by imposes liability is there is no escape. There's no escaping the contract. In this case, the insured can void it. If that were removed, and we had, for example, the contract that said, we will do the $20,000 in tear-out work, period, and that were signed, that would impose liability.
Again, isn't the escape clause, though, that the insurance company won't pay for it, correct?
The escape clause allows her to void it if there is no coverage or no payment. And that is how the insured escapes liability. And so I'd submit to the court that liability cannot be considered to have attached if there's still a way to avoid liability.
So I guess I'm still trying to figure out what your answer is. So if they said, okay, I've just listened to all those people over in Daytona Beach today, you, Ms. McClendon, APT, will say, here's a contract. One, I agree to pay you $12,000, whatever number. You agree to do this tear-out work that's defined in the appraisal award, dated, September 21, 2023, and says, here you go, State Farm. So I guess in theory, and if she then didn't allow them to do that work, she barred them from coming in the door, and they sued her, even though they haven't performed the work yet, that would be, State Farm would pay under that? That's an enforceable contract, or that's a contract of which she's liable under? Is that what you're saying?
If those were the terms of the contract that Your Honor just outlined?
Those are my contract terms here. I'm trying to figure out, okay, they shouldn't pay it. What is it that State Farm is going to require her or any insured in this scenario to do, in State Farm's view, to have a valid contract? Because, I mean, at the end of the day, if she signed the contract that I just hypothetically set forth, I guess she could just say, I've changed my mind, I'm not letting you in. Is that company, I'm envisioning State Farm would say, well, then they have to then sue her, and then they have to get a judgment. Now she's, quote, liable there, and then we'll give you the money. Is that, am I walking the scenario through correctly?
I understand your hypothetical now, Judge. Thank you for clarifying. So in your hypothetical, the contract terms that you've outlined would impose liability on the insured. Once that contract is provided to State Farm, the payment would be issued because liability would attach. The next step of Your Honor's hypothetical...
Well, let me then follow, and I'm not suggesting deviousness on behalf of Ms. McClendon or anybody similarly situated, but so, okay, she gives you the contract you guys are happy with, you write her the check for $12,000, what have you, then she goes buys the lottery tickets, and APT goes away. You guys are saying, hey, policy language was met, that's a fight between APT and McClendon, assuming there wasn't some, quote, fraudulent behavior between the two of them.
Right.
Then you guys, well, closed file, go to the next one.
Assuming there's no fraudulent behavior or intent to deceive or anything along those lines, any dispute that arises after that point
Yeah.
between Ms. McClendon and APT is between those two.
Let me make it more altruistic on Miss McClendon's point. She gets the check and she finds out that her child is in serious health issues and she needs to spend that money to help the child. And she says, you know, that was really nice at State Farm, but between fixing my what have you, or giving, you know, providing the hospital expenses or paying the bills for my 19-year-old son, that's the route I had to go. I apologize, but that's how it turned out. Sorry, Mr. APT. And APT says, boy, I hope your son's doing well. Have a nice day. I should have been a law professor listening to this. But, I mean, in that scenario, then I'm just trying to envision, you know, what the parameters, I mean, what it really is going to tell, the parameters of what you guys are saying is a valid contract. Under that scenario where I've added that, you've gotten, in your mind, you guys have gotten a valid contract, you've paid the money, whether APT or whatever chooses to enforce it when she had to go spend the money for the medical expenses for her adult son, that's between APT and your homeowner or your insured. You guys have complied with the policy and you've got no more beef with her.
Unfortunately, Your Honor, I really can't speak to what happens between APT and the insured after the fact, because that is in fact.
Well, that's what I've
between
told you the
those two
facts are,
parties.
as I find as a trial judge.
Correct. So State Farm really can't address what happens between those two and any agreements they make or any breach of that contract that may or may not exist.
But they've gotten a valid contract. In State Farm's mind at that point, it looks like she's liable to APT. Whether down the road APT just bites the bullet and says, unusual circumstances, we're not going to pursue it. We know she got the State Farm money to pay us, but, you know, we're doing our good deed for the year. And I'm not maligning APT. I don't know who they are, but.
Certainly. In that situation, the terms of the contract that Your Honor outlined would be the ones that
That's
control.
an incurred expense under the policy.
That is an incurred expense under the contract. What happens after the fact, obviously there are hundreds of different scenarios that could arise, and I guess that would have to be addressed on an individual set of circumstances after the fact. But in all of those hypotheticals that Your Honor and I just went through, the key is that there was a contract that imposed liability and then a payment was made. All of the other scenarios that happen after the fact, we can address those as the facts may warrant. But the critical distinction between the contract Your Honor was talking about and the contract that we have in this case is that there was not an escape in Your Honor's hypothetical contract. Here, there is an escape that allows the insured to get away from liability. So that still remains to be imposed. It hasn't attached, as the Boer case says.
So there's an appraisal award in this case, correct?
There is, Your Honor.
Okay, so why does the lost payment provision not apply?
Because the lost payment provision is the general provision of the policy. The case law is developed in such a way that if there is a more specific provision, then that provision controls when payment is due. And that's the more specific provision we're relying on in this case is the cost you incur provision.
You would agree, though, in the lost payment provision, it talks about the appraisal award, correct?
It does,
And then
Your Honor.
paying it within 60 days after the proof of loss?
It does, Your Honor.
Okay.
And
So you're saying, is that referenced anywhere in the tear-out clause?
It is
That the
not.
lost payment provision does not apply?
It does not specifically say that in the tear-out clause. But I don't think that prevents a barrier to the payment. And the best case I can think of to exemplify that is the Everhart versus Citizens case from the first DCA. And in Everhart, there was an appraisal award that included an amount for ordinance and law. And ordinance and law has the same cost you incur language as the tear-out provision. And the ordinance and law provision, just like tear-out, doesn't reference the lost payment. And what it was actually a concurrence that said it. It was a very short opinion with a concurrence that explained a little more. What the concurrence in Everhart said is that the insured had not incurred that amount for ordinance and law identified in the appraisal award yet. So the payment wasn't due yet. And I'd submit that's the same analysis that applies in this particular case. And we've cited a number of cases in our brief that explain when you have an appraisal award, that doesn't alter the other terms of the contract. It simply sets the amount of the loss and allows the parties to apply the other terms of the contract. And so in this case, the tear-out provision with the incurred requirement is still applicable. And unless the court has any specific questions for me, I see that I'm getting very close to my rebuttal time, so I will save the remainder.
Okay, thank you, sir. Good
Good morning, Mark Nation on behalf of the appellate. counsel and I were just in Jacksonville about 60 days ago.
For him?
Yep.
Okay.
In the 5th DCA, which was hard to get used to, and having this argument. So it's been almost 60 days. I asked them to write an opinion based on the questions being asked similar today. We haven't gotten an opinion. Judge Maker, Judge Sald, and Judge Jay were on that panel.
All right.
And so I just want you to know it seems like they're probably working on a written opinion on this issue. We've also argued in the 2nd DCA.
So they haven't ruled yet, and they had
have
it a
not.
couple months ago? All right.
Yeah, and the 2nd DCA just issued a PCA on this issue. Same counsel, same arguments, same issues.
In your favor?
In my favor. All right. And so I'll just address a couple of the questions. As far as Sabello is concerned, as we think about Sabello, there was no breach in Sabello. They paid the policy limits in that case, and then the insured wanted coverage for law and ordinance. And what the Supreme Court said in that circumstance is, wait a minute, go start the work, and then if you actually have those expenses for law and ordinance, which is additional costs which you incur as a result of upgrades for code, then submit that claim. On the last page, it talks about the definition that the Claimants Council, I think it was, Citizens Council agreed to. What Judge Jay said in the oral argument that we had, and he came out right out at the top, is that's not the only definition of incur. There are lots of definitions of incur. And the definition he wanted to talk about was to suffer. Black's Law Dictionary says incur means to suffer. Here, Ms. McClendon has suffered a loss. And I do want to contrast tear out with law and ordinance, because the cases they rely on are law and ordinance, and Sabello is, again, no breach. Here we have a breach. There was a breach of contract. The appraisers awarded more money. And tear out is money to access the thing that caused the loss. Very different than law and ordinance. It's a different type of coverage. And it doesn't make sense that State Farm would pay for the water damage and say, here's your money for your water damage. Go do that. But we won't pay for the thing that caused it. Even though the loss payment provision is triggered, we won't pay for the thing that caused it unless you enter into a contract which we approve. Now, that just doesn't make any sense logically that they would hold back the payment on the thing that caused the loss, nor are they allowed to address, the case law cited in my brief talks about a third party to a contract, even an insurance company whose payment is dependent upon it, can't come and attack a contract and say it's not enforceable. And this contract is clearly enforceable. They're using judicious use of ellipsis to say it's voidable at any time. It's not. It's only voidable when I've set forth all of the criteria, and there are about 5 of them, if those 5 things occur, none of which have happened in this case. For that provision for voidability to apply, there has to have been the insurance company has no liability. They don't owe anything. Here, they're required to pay. And if you look at what their argument is this, according to them, this contract is only enforceable if we pay, and we're not going to pay because the contract's not enforceable. It's just a circle. The provision that they're relying on isn't the provision that applied in this case. It's the second one. And on the contract, it says, if my client is paid less than the full amount, we agree to negotiate scope. And they're withholding the payment so that can't happen. So I really don't want to belabor the point. I suspect the other panel is writing on it, but if I can get a written opinion on this, it'd be very helpful, because this is happening in a lot of circuit courts, in my cases, throughout the state. Nothing further. Thank you.
Thank you, Mr. Nation. All right, just over 6 minutes.
Thank you, Your Honor. I'll address 3 points that Mr. Nation brought up. The first is Mr. Nation argued that a third party to a contract cannot attack the validity of the contract. And I think this was clear in our briefs, but I want to make sure that we're real clear on this. We're not attacking the validity of the contract. The issue we have with the contract is, as I mentioned before, that there is still an escape clause, which means that liability has not attached yet, and that's the requirement for incurring a cost under the policy. The second issue that I want to address is counsel's comments about the other argument before this court, and specifically Judge Jay's question with respect to the definition of incur. And Black's Law Dictionary does define incur as to suffer or bring on oneself a liability or expense. I think it's really important when we start dealing with that definition to recognize the distinction between damage and the cost to repair the damage. The damage here has occurred, so it's very easy to say that the insured has suffered the damage. But that is not the same thing as incurring the cost to repair the damage. And that's the provision of the policy that's at issue, the cost you incur. So if we are suffering a cost, incurring a cost, becoming liable for a cost, all of that, again, the same thing, recognizes an obligation for the cost. It is not the existence of damage. And we have to focus on that obligation to pay the cost, which is what we've talked about in the initial argument. The final point that I want to bring up, Mr. Nation mentioned that the argument is essentially circular based on the provision of the APT contract. And I'd submit to the court that it's not a circular argument. What the APT contract does is try to work backwards from what the policy requires. The policy, again, the language, the cost you incur. The Sabalo case states that unambiguously requires the insured to incur the expense before payment is due. So under that language, it is incurring the expense first, payment second. When we look at the APT contract, it has an escape clause up to the point that State Farm issues payment. So essentially, it requires payment first and then liability attaching second. So it's actually the opposite of the way that the policy should work. And again, all we're asking for is to apply the plain language of the policy and have a contract that satisfies that requirement, that liability for the cost of tear out is imposed on the insured without an escape or another out, for lack of a better word. Once that is presented, State Farm will issue the payment. And that's what we're asking for, and we believe that's the decision the trial court should have reached. So we're asking this court to reverse and remand with those instructions. Now, unless the court has any other questions for me, we'll rest on our briefs.
Okay, thank you, sir. Thank you both for a very well-argued, well-briefed case.
Half they're out.
I like that idea. I could probably get half.
See if they can find your dad. That's what they ought to do.
That is a good test.
Joey's got to find your dad up here on the pictures. If he doesn't do that, he's out.
Yes. All right, good morning again. Next case on the docket, 23821, O'Day versus O'Day as personal representative. Again, 20 minutes per side. Appellant can reserve as much of that as you would like for rebuttal. I'll set it at 5 minutes unless you would like something other than that. And when you are ready, you may proceed.
Thank you. Good morning. May it please the court. My name is Kelly Feig. I represent the appellant, Hannah Alcor, previously Hannah O'Day. And before I begin, I just want to let the court know that this is, although I've been a member of the bar since 2007, this is the first time I've had an opportunity to make oral arguments. So
In front of us?
A little excited. No, at all.
Oh, at all.
Never.
Okay. Well, good luck.
Thank you. Ms. Alcor comes before the court this morning seeking a reversal of an order from the trial court that denied her petition to remove the personal representative. the court has jurisdiction under 9.170B, subsection 6.
Because the PR is a fiduciary.
Correct.
Okay.
And the standard of review on removing a personal representative, since it's a discretionary decision of the trial court, is an abuse of discretion, except where the court relies incorrectly on law, it would be a de novo review. And what I would like to focus my time on today is the second argument in my initial brief, which was that the trial court's failure to remove the personal representative was an abuse of discretion.
So there's two assets in the estate that you're claiming. One is this settlement, is that correct? That's one of the assets, and then the other is whatever interest might be in the JS Land Trust, correct?
Correct.
Okay, and the trial court ruled that the JS Land Trust is not part of the estate, correct?
Correct.
So other than those two assets, what else is there to administer?
I don't understand your question. Are you asking how much further in the estate?
What else is there to do? What point would there be for, my understanding is that from the record below that the amount that is owed to your client is sitting in a restricted account. And so what point, I guess this is what I understood the trial court to say is, what would be the reason for removing the personal representative at this point? What else is there left to do?
Thank you, Your Honor. So what is left to do, there's multiple parts that I want to address in what you said, but first I will answer. What there's left to do, from my understanding, is basically approve the final accounting, and you would be finished with the administration of the estate. Going back to the JS Land Trust issue, that was brought up by my opponent in the trial court at trial, where they first announced that the decedent has no interest in the JS Land Trust. However, in the appellee's initial verified answer, he admits it. It's number 3 on his verified answer. There is an amended verified answer where he still admits it, also number 3. And there are sworn answers to admissions, a request for admission, his sworn answers and his amended sworn answers.
So is your sole reason for saying that I think it would be 1/3 interest of the JS Land Trust as part of the estate is based on his representation in the inventory and in the answers?
In the 3 inventories, the answers and the
so I think below
admission.
I think below you said, you stated it's by implication.
Correct.
That's what you said, by implication. So that's your sole reason for believing that the estate is entitled to, or that's your position that the estate is entitled to 1/3 interest. Is that what you were arguing?
No, it has never been an issue. It was never a contested issue that the 1/3 interest in the JS Land Trust belonged to the estate. And one of the issues that I raise in my brief, which is judicial estoppel, because my opponent in the family case in August, just a few months prior, argued that the JS Land Trust is not a marital asset, but it is a probate asset. And the appellee also testified at the divorce trial that the JS Land Trust is, and I can give you the page in the, I think it's 38 of my initial brief. But he also testified at the divorce that it was part of the probate, and the judge in the divorce case agreed, and they won on that issue. And 3 months later, they're coming into the probate court for the first time in 3.5 years to assert that it's a marital asset and not a probate asset.
So what was, I mean, in the land trust, the JS land trust, there was a piece of property in Tampa, right?
There were two properties.
That was sold,
Judge
and
Lambert.
wasn't that put into the parties' joint account, the proceeds?
So there's no evidence or testimony that states that it was put into the parties' joint account. There is a copy of the check from the trustee at the time, Jawad Saima, who received a check from selling the Tampa property, and the only person that signs off on that check is the appellate, Mr. Ode, and there's no evidence that was presented except for Mr. Ode's testimony that he put it in the joint account, but they did not present any evidence. My client, of course, also testified below and stated that it did not go in the joint account.
The Leesburg property that Judge Lambert referenced, that's been sold, correct?
That has also been sold, but the estate asset regarding that property, what we're asserting, is the mortgage on that. And that Mr. Ode, when he sold the property, sold it at a 0% mortgage encumbering that land trust. The only beneficiary of the land trust.
Did you ask below, though, to void that sale? I believe below in your pleadings you asked to void the sale to the to the Leesburg property?
Correct. At the time, that's what we had pled.
Okay, but you would have. Did you notify the party that was actually purchased the prop? They would have had to been noticed, correct?
Correct.
Okay.
Correct, Judge Boatwright. And I had many conversations with the attorney that was representing the buyer. And
Well, who's the mortgagee on that sale regarding that? Who gets the monthly payment?
So the land trust is supposed to get the monthly payments, the beneficiary of the land trust, but it goes directly via Zelle into Mr. Ode's personal account. There were hearings below regarding the money, since everybody was on the same page that the estate had a 1/3 interest in that mortgage. And it was represented by Mr. Ode's first counsel, Mr. Urchin, that the money was going into the estate account, which wasn't true at the time. And so he began depositing money, but then stopped.
Well, let me ask, what we're here about today is you're saying that the trial court reversibly erred by not removing Mr. Ode?
Yes.
By not removing him as the PR. And part of that is because he's not administering the estate the way you believe he should be administering under the statute. But if the trial judge finds that the JS Land Trust is not an asset of the estate, then by definition, he's not maladministering the estate vis-a-vis that property, right?
As to the mortgage, but he still maladministered the estate, Judge Lambert. But
what I'm asking is, like, following what Judge Boatwright asked earlier, the assets of the estate are the settlement regarding their adult son.
It's in cash now, yes.
It's who?
It's in cash. The settlement came
Right.
So it's the proceeds, yes.
There's money to be distributed, so that's an asset. And the other asset is this JS Land Trust, interest in the JS Land Trust.
It's as placed on the inventory, the 3 inventories, it's an interest in the 1/3 interest in the mortgage coming in to the beneficiary of the JS Land Trust. The only entity that's no longer a valid corporation or a limited liability company that was the beneficiary of that land trust was AMA Investment Management LLC. That's the only beneficiary of the land trust and was always the only beneficiary of the land trust. And that corporation had 3 officers.
And that corporation is dissolved now, correct?
Correct. It dissolved 1 year later.
1 year after the death of their son, right? Or no?
Correct.
Okay. So that's the beneficiary of the trust.
Correct.
And so that's a dissolved corporation or entity, a dissolved LLC. So how does, I'm still trying to get to the point of, all right, so if I'm the PR of this estate, how am I maladministrating the estate vis-a-vis the interest of a now dissolved LLC who was the beneficiary of the trust that owned these assets?
Because at the time that the LLC, well, really at the time of death, the LLC was in existence, and there's no operating agreement for that LLC. And so we go to the default rules under Florida Statute 605.0602, which states that if there is nothing else, there's nothing in the operating agreement which dictates what happens when a member passes, then those rules kick in, which essentially say that it would pass via whatever the will or the trust of the decedent says, or the intestacy statute.
But the decedent here didn't have a will, correct?
He did not. And so, therefore, at the time of death, his interest, the decedent's interest in AMA Investment Limited, management, would have gone, since he had no spouse and no children, to the parents, and he had a 1/3 interest at the time in that corporation company.
So the statute you referenced, I believe it was raised by the appellee, states that those interests should have gone to the other brother and sister. Is that not correct?
I didn't hear your question.
So with AMA, there were 3 members, right? There were the 3 children?
Correct.
And then the decedent in this case died, so we're left with 2 children, correct?
Correct.
Okay, and then the argument by appellee is that, the trial court below, the trial court stated that the interest of the decedent in this case would go to those 2 individuals, to the other 2 brother and sister. Are you not in agreement with that?
I'm not in agreement with that. That's not the default. It's 6050602. Do the judges have any other questions in regard to that property or the JS Land Trust? I think another issue with the trial court with the land trust was that the trial court didn't differentiate, and this has been an issue, in these proceedings going earlier, even when I tried for my motion for partial summary judgment. But I don't think that there's an understanding between what a trust is under the trust code and a land trust, and I think that that's where a lot of the confusion arose. Of course, the court's order looks at 733-504, which is the removal statute, and the 3 subsections, which is subsection 4, subsection 5, and subsection 9, I believe, that we raised. The second one, subsection 5, being the wasting and maladministration, which we've been addressing, but there are more issues regarding the maladministration. This estate has not filed a tax return yet, an income tax return at all, even though this money's been sitting there since 2020. And the money has not been invested. Mr. Oda never inquired as to, from a financial advisor, some sort of conservative investment for the money, and the cases of...
Why doesn't your client just take her 1/2? I mean, there's X dollars that were distributed as the settlement. I know that the PR took $36,000 in some fashion preemptively here, but the judge basically said, okay, that comes out of his half, and that was not good, but that's not enough for me to want to remove the guy. Here, appellant, you take your half, you Mr. PR take your other half, your remaining net, and that would then your client could invest away, right?
I understand what you're saying, Judge Lambert, and thank you, but I think that the purpose of our rules and our laws is so that the citizens of the state can have confidence that they can resolve a dispute in our courts and get a fair result. And this case has been going on for over 3 years, and every time we got close to trial, the appellees would fire his counsel, or they would withdraw. I I think they all withdrew, actually. They would withdraw, and then he would get new counsel, which would continue to make the case go longer and longer. At one point, the appellee even asked for a stay so he could go look for new counsel. And really, it's the appellee is trying to get an end run, I think, on justice, right? He's getting an end run by saying, I'm just going to drag this out long enough so that all these bad things that I did don't matter because there's only this left. And it's like, I was talking to the other attorney, it's like when there's a breach of contract case and the debtor says, well, I'm going to declare bankruptcy, or I don't have the money, so what's the point of you suing me? You know, contract law is not based on enforcement. Otherwise, it would take all the meaning out of privity of contract, right? What's the point? And it's the same thing here. We have these rules that govern a fiduciary in a position of trust, which just simply didn't happen.
But the statute says may. It's a discretionary call. It's the same rule. If you want to expand upon the rules, the judge has the discretion to say, I've listened to this. I hear what this case is about. Yeah, you might not have been the best PR I've ever seen, and you advance, but I can resolve that by simply saying, you know, you're 30, you've already taken 36, give her her half, close the estate, goodbye, move on.
Correct, but a party to a lawsuit should be able to rely on presentations from another lawyer or from a fiduciary without having to dig into litigation like this. Appellee's first attorney represented several times that all the money is in the bank, nothing has been distributed, nothing is even anticipated to be distributed. Only upon rumors did my client start digging, and there are a lot of cases that really outline what is enough for a court, what is enough and what is not enough for a court to remove. And if you look at the trial, and this case, sorry, I keep cutting my own self off, but this case, I'm running out of time. This case actually is more egregious than a lot of the cases that I cited. And if you look at the court's order in paragraph 6 and 7, I think it's 7. I'm trying to find the court's reasoning here. A moment. Because you mentioned the 50%. And we never contested the 50%. I'm sorry, it's paragraph 14. The court states, the court finds, even though everyone admitted that he took the money, which was only discovered because I forced the issue of providing records, there was no inventory even for 2 years. The court finds that the personal representative's removal of $35,000 concurrent with tendering to the wife her portion of 50% does not rise to the level of wasting or maladministration because it will be denied. And she says somewhere else up here, but that was not the paragraph I was looking for, that he offered her 50% and she takes, oh here, I'm sorry, it's paragraph 10. She says, it doesn't rise to the level because the wife rejected the 50%, which is not true, it had never been contested, by letter dated July 28th, asking for 172. There's nothing in evidence. That letter is not in evidence. That email, whatever it was, it's not in evidence. There's nothing in evidence that reflects that she asked for more than 50%. And I'm over my time. Thank you.
Okay, thank you.
She used all 20?
Yeah.
Do you need to get something?
Yeah, sorry. I didn't want to interrupt. Thank you.
Okay.
Good morning. May it please the court. My name is Kelly Johnson, and I represent the appellee, Madhair O'Day, as personal representative of the estate of Adele O'Day. As the court is aware, the position that the appellate took in their answer brief was that this matter, that the court didn't have jurisdiction over the order in this case.
Why not?
Specifically because it did not finally resolve a right or an obligation of the party in this matter. While I understand that the rules of procedure list the removal or appointment or refusal to remove a fiduciary as one of those orders that could be appealed as a final order,
That's what's here, right?
that's what's before the court. I would argue that the order from the trial court is not a final order, and that is because
But it's an appealable order. I mean, it doesn't close the estate, but it's one of the numerous listed appealable orders in probate under 9.170B. I mean, and it was...
Theoretically, yes.
Well, why is that theoretical? I mean, is it a fiduciary, is it a PR as a fiduciary?
Yes, Your Honor.
Okay, so we agree with that number. I mean, they could have...
I agree with that, yes.
All right, so...
My argument is to the finality requirement.
But doesn't the rule itself said orders that finally determine a right or obligation include but are not limited to orders that remove or refuse to remove a fiduciary?
Correct.
I mean, the rule itself says it's a final, it's got some finality to it.
That those orders could have some finality to it. I would argue that the rules don't contemplate this type of scenario in which there's a probate case that only has one, possibly two assets. Nothing needs to be
What does
managed.
that have to do? What if there was 50 assets? How does that become dispositive vis-a-vis the language of the rule?
Well, I believe if there's a fiduciary duty to continue to manage assets of the estate, then the removal of that fiduciary would be pertinent.
Well,
and
but I
would be
mean, their
appealable.
position is, okay, the guy took $36,000, $1,035, clearly had no authority to do that just outright. That's bad, that's maladministering the estate. Maybe the net effect, as the probate judge said, well, we'll just deduct that from your share. But I mean, it's still, that's not things that PR should be doing absent court permission, or unless the will actually said to do that, which we have none here.
Correct.
Then, all right, so that's a reason to say, I don't have a trust of this PR. I would like her or him removed, and they petition. They're unsuccessful, so it was an order that did not permit the removal of a fiduciary, and the rule written by the Supreme Court allows somebody to appeal that as a matter of course here, so we would have jurisdiction. Now, whether it's successful, I mean, that's, and then the last part of the rule says, and you could call up any other order that was entered that was not otherwise appealable, which would be the order denying the motion for summary judgment, just like in a regular, at the end of a civil trial. I mean, that's
Correct.
You can. I mean, I don't know that it much matters here, because I think the summary judgment requests and the trial requests are the same. Remove your guy, so
Correct.
he either is going to be removed by us reversing or not, but it's still within our bailiwick, or using Judge Boatwright's buddy Scalia, it's within our jurisdiction to do this, to address it, right? Now, does that become problematic vis-a-vis what you're talking about today, because all you talked about was jurisdiction?
No, I will respond to the appellate's argument orally to the court as far as...
Is that okay, in the sense that, they've made their argument, you've not responded substantively to their argument because you've wrote on the jurisdictional discussion, but so she doesn't have the benefit of saying, well, if you don't like my jurisdictional argument, panel, here's why I think she substantively doesn't win. That's not part of the, so, I don't know, he's the guy presiding, so.
No, I agree. I think you're limited to the arguments raised in your brief or questions that we ask.
Yeah, I mean, if we could, she might not like it, your opponent might not like it if we start diving into the substance of her argument and ask you to respond, because you've not responded to her in writing with an answer brief as to that issue.
As to that issue, yes.
So you have to wait to see if
Judge Harris throws out the bait or something like that. So, or Judge Boatwright, I guess he's more the fisherman. I'm not the fisherman, so I have no bait to throw.
No, I have no specific questions. Is there anything further that's raised in your answer brief that you would like to argue this morning?
No, Your Honor.
Okay. All right, thank you. You do.
Well, just since this, I mean, so your rebuttal would be in to respond to what your opposing counsel just said, who we've told we have jurisdiction.
I literally have a 5-second or 10-second.
Hey, your 10
statement.
seconds worth.
Thank you, Your Honor. I just wanted to remind and point out, which has been pointed out, that the appellate does not contest any of the substantive arguments or breaches that were alleged in the initial brief, and or any of the arguments as to the errors of the trial court. That's all. Thank you.
Yeah.
All right, thank you very much.
Yeah,
both
she
of
said
you.
we shouldn't even hear it at two jurisdictions, what her answer brief was. So, okay, thank you. There you go.
There you go.
There you made it. Eh?
Oh, we gotta wait till 11 anyway.
We have to wait till 11 because we're streamed, we're live streamed and all.
All right, court will be in recess till 11 o'clock.
Oh, he's over there, look at that.
He's done, right?
Yeah.
Yeah.
Did what he could do and spent 5 years in school doing it and.
And now, what are you doing with your time? Now that you're not running off to baseball games and.
I've just been so busy.
Yeah, I'm saying.
How about you? How's the baseball season going for you?
It's going just fine. They're just starting up. He's got a tournament this weekend, and he's playing more basketball now. So, of course, there's a basketball tournament and a baseball tournament. So we'll be running around like chickens with our head cut off. But that seems to be what we do these days.
Well, yeah, this last year was my first year in 15 years that I haven't been doing it, and it's weird.
I bet. Yeah, I don't know what I do. I don't know what we did. My wife and I always joke. I don't know what we did before.
Yeah.
You know, probably talked. Went out to dinner.
Well, my friends, your friends kind of become the people that you're on the ball fields and all that kind of thing. So
Yeah.
that's just kind of what happens. So we should be just kind of getting reacquainted with everybody, but I've just been so busy. So many cases are set for trial, and it's just you've got this crunch. You've got all these new cases getting filed.
Well, the case management deadlines too. I know for you guys it's tough.
Yeah, so it's just been a hectic year.
This is my third oral argument this week.
Really?
It's Thursday. So.
Well, hey, this will be my first in 32 years.
There you go. Hey, I don't know. This seems like a cake. Well, famous last words, but I don't know how you guys go to trial. I mean, I just feel like I've been twice. I think it took like 3 years off my life, both times. It's tough.
Well, I had an arbitration. Since I do long-term care work, we do a lot of arbitrations.
Yeah.
Or I should say, we have arbitration agreements, and so that's a big litigation issue. But then you try, it's so you're kind of on a rush to get them to arbitration. So 2 weeks ago, I was in an arbitration. It's interesting being in that setting versus a jury. It's much more
Never been to an
relaxed.
arbitration. I've had appeals from them, but I've never actually sat through one.
Yeah. You got it wasn't a panel, it was just one lawyer, arbitrator.
Yeah.
And it was much more relaxed. And you're not going to the courthouse, you're not.
Deal with the jury.
Yeah, and we actually did it by Zoom.
Okay.
Which is crazy.
That's great.
All right, let me get my papers here, see what I have. You've done 3 oral arguments this week.
Yeah, since Thursday.
Yeah, me.
2 in the 6th, and then 1 here. So, I might be having a Bloody Mary with my lunch after this one. It's been a long week.
Oh my goodness.
please be seated.
You can only say that once as the marshal. Once a day, is it his contract?
All right, our final case this morning, 23-239 Baker versus BLC Atrium Jacksonville. 20 minutes per side. Appellant can reserve as much of that as you would like for rebuttal. The default's 5 minutes. If you want anything other than that, please let me know. And with that, Mr. Brownlee, if you're ready, you may proceed.
May it please the court. Good morning, Your Honors. Almost good afternoon. My name is Mike Brownlee. I'm here on behalf of the appellant, Daryl Baker, and I would like to take 5 minutes for rebuttal.
Yes, sir.
Your Honors, this appeal arises from the dismissal of Mr. Baker's lawsuit with prejudice for fraud in the court. And before we get into it in earnest, I want to make something really clear. Mr. Baker understands, I understand the trial court's frustration and concern, the appellee's frustration and concern. Anytime a party answers a question under oath incorrectly, it's a problem. It deserves to be vetted. Our position is simply that the punishment doesn't fit the crime.
This didn't happen one time, right? This happened several times.
It happened in his deposition. There were 2 questions he answered incorrectly, and then
About the interrogatories.
the update interrogatories, he failed to update them. When he answered the original interrogatories, the answers were correct. He had not started working at Amazon or suffered any sort of injury. So, but yes, that's correct. He didn't update his interrogatories like he was supposed to.
What about to the life care planner?
Well, I think the life care, if you read the report of the life, we didn't have any testimony from Dr. Lieber, who was the life care planner, and I think if you read his report, it's less clear than it's made out to be in the briefing, in my opinion, about his responses to questions about his current employment. I think when you read the report and he's asked about his employment, to me, I mean, again, you're reading from a cold record, but it looks to me like he's responding to a question about his employment with the newspaper, rather than just his employment in general. I'd like to focus, we raised a series of arguments in the briefing, but I'd like to focus the court's attention today on 2 sort of main issues. And one is the burden of proof that the appellee had to justify the extreme sanction of dismissal, which is clear and convincing evidence. Mr. Baker testified at the hearing that memory problems and cognition problems were the basis for his inaccurate reporting in the discovery and in the deposition. Whether you believe that or not, it was unrebutted. There wasn't even one question asked in cross-examination. There was not a witness called to challenge his testimony that that was the basis for his problems. And there's support in the medical records for his explanation. He got his bell rung badly when he fell at the senior center. That's not disputed. And I'd like to point the court's attention at page 1352 of the record. There's a recap of Mr. Baker's visit with the neurologist, and this is 2 years after his deposition, where he's being treated for decreased memory and retention, and he's struggling with cognition. Those are direct quotes from the medical record. At page 1354 of the record, he's visiting an optometrist, and the optometrist notes that he has brain damage.
But isn't the problem that the trial judge had, I'm gleaning from this record, that it's not like your guy was asked a question, did you see a chiropractor 8 years ago and you forgot about your... He was asked a question about what was he doing now. I mean, he's working at the time he's being deposed, and he can't remember that he's working or he'd been injured there, and the judge finds that incredulous, or I can't remember the term exactly, and yet your client remembers other things. So the judge gleans from that information as the trier of fact, the weigher of credibility, that I don't buy it. I mean, it's one thing you don't remember stuff before you, and granted, as you get older, you remember less and less. I get that, but it's happening at the time, and you tell somebody the exact opposite of what's happening to you. In other words, did you go to work today? No. Well, you were at work. What are you talking about? How do you not remember you were at work before you came to? I mean, I know it wasn't that graphic,
No,
but
I understand.
but I think that's what's the sense of what the trial judge is doing.
I think that's an accurate, recap of what the trial court's concern was, definitely.
And even though there's no testimony from your opponent's side saying, there's no evidence of brain injury, the trial judge doesn't have to accept that the brain injury causes this kind of memory lapse, does he?
No, I think in the ordinary circumstance, no. But where it's supported in the medical records and it's not challenged at all via testimony or even a single question on cross-examination, I mean, it's really just floating out there unrebutted. I do think in that circumstance, given the gravity of the right that's being taken away, which is your constitutional right to a jury trial, I think you put that to a jury. You know, the jury.
So absent any evidence of brain injury, if your client provided these same kind of answers, you've got a real difficult time reversing this.
100%. And I think, Judge Lambert, that's what distinguishes this case from the other cases that talk about, look, you can't just say, I forgot, yeah. Right? I mean, because in those cases, the courts take pains to note that there is not any sort of evidence to buttress that explanation. But here there is. And I think it's enough to show that the senior center did not prove their case by clear and convincing evidence. So first issue is the clear and convincing evidence standard. The second one is the materiality of the shoulder injury and his Amazon employment to the facts of this case and the type of damages he's requesting. He's never requested damages associated with the shoulder injury. It's for his neck surgery and for his back. It's simply not a part of the case. The shoulder resolved. It's not an important part of the case. And I think one fact that underscores that it wasn't an important part of the case is that the senior center knew about this for 2 years before it filed its motion to dismiss. For 2 years. Logic would suggest if this is truly the central, a pivotal piece of the case, like it has to be under the law, that the senior center would have broached this issue in some, way, shape, or form, after the summary judgment motion had been denied and they're at the eve of trial and they're about to go to trial. You would think at least in their summary judgment motion or elsewhere that there'd be some discussion of this or some effort to adduce testimony about it or whatever. But sitting on it for 2 years without doing anything about it seems antithetical.
So you're arguing they're not prejudiced? Is that what you're arguing?
Correct. Yeah.
Is that an element, though, of dismissing this with fraud?
It's not, as far as I know. Well, let me temper that a little bit. I mean, I think a lot of the cases talk about, is this scheme to defraud? Does it hamper the defense and then their presentation of the case? And I think here, absolutely not. It didn't, because A, it's not a central issue, and B, they had this information for 2 years, didn't do anything to vet it.
That was not a central issue, though. I mean, you allege in your complaint he has an inability to lead a normal life, and then he's out working 40 hours a week at Amazon moving boxes.
It wasn't 40 hours a week, but understood.
What was it, 36?
I think
Was that 3 12-hour days?
I think it varied.
3 12-hour days a week, I thought.
Yeah, I think in some instances that's correct. I think he also testified that there were 4-hour shifts, but I understand your point. But the loss of enjoyment of life, the damages he was claiming, they were associated with his neck and his back, and this is stuff that could be easily dealt with the jury.
Even though he decided not to pursue a lost wage claim, this seems to be an apples to oranges thing. I mean, let's say he wasn't working at Amazon. Let's say he was working as a minor league professional hockey player, and during this same period of time, he's being deposed. And so he's being knocked into the boards, gets in fights, and going back and forth. A very, very vigorous, difficult sport. And that was his job. And he's asked by the opponent in deposition, well, are you working? No, I'm not. Well, okay, but he is. He's working as a hockey player here, and maybe we don't hear him because he's not a professional hockey player. I don't see him on TV. But I mean, that goes to his ability to do things, to enjoy life. I mean, that would certainly be a critical thing, I would think, if you're on a jury, is saying, well, wait a minute. You slipped and fell and you're asking for all these damages, but here we see that you're a hockey player. Right. So you're probably not really in that great you might be in a lot of pain and suffering from playing hockey, but it may not be related to this, so it greatly affects how a jury would look at the value of the case, and to not disclose it. Again, let's use my hypothetical. Let's say he had no brain injury. Not disclosing that would seem to be almost the epitome of trying to be fraudulent and to hide something so that hopefully the opponent would not discover that I actually, in full contact karate, hockey, or whatever I'm doing, and maybe I don't really need $500,000 for rehab or or future medical care. I mean, that's kind of
I understand.
So, I mean, the argument that, well, it's not a lost wage claim, I sort of like what Judge Boatwright is saying, that to me is not the critical thing. The critical thing is you're doing a job that apparently requires some type of physical labor that's inconsistent with what his claims of how his life has been affected by the slip and fall at that guy's place. And you didn't want to talk about that, or you intentionally told somebody a different story. Because if you said, yeah, I'm working, and they say, oh, what do you do? Well, okay. That causes a reevaluation of the case from both sides, I would think.
Yeah, I understand.
Yeah,
I mean,
fine.
I think if you stack this case up against the other cases that say, nope, it's okay to dismiss someone's entire case with prejudice, the facts of this case, they don't stack up.
We look at, I mean, and the other thing that weighs against you, I mean, your judge got to listen to your fella and make credibility calls, and then we have to look at those. We defer to the factual determinations of credibility calls as an abuse of discretion, although it's a heightened abuse of discretion standard that we apply, which I guess means that it's not a complete abuse of discretion. It's, yeah, you know, we're looking at you a little more closely than just saying, well, it's a discretionary call, and we might have done something different, but it's a discretionary call.
Right. No reasonable judge, just a semi-reasonable judge. I don't know.
Find a lot of those around here, but
I understand. I suppose the upshot of our argument is this is stuff that could be dealt with a jury. If this court reverses and gives Mr. Baker his day in court before a jury, he's going to have to answer for all of this. It's not like this is just going to be swept under the rug. He provided this inconsistent testimony. This can all be presented to the jury, so his constitutional right can still be preserved, and at the same time he can answer for the misdeeds that...
So at some point you were served with these employment records, that the other side served you with employment records from Amazon that showed you that, now, wait a minute, they know that he's working at Amazon. Prior to that, them serving those records, did your client ever indicate or inform the other side that he was working at Amazon?
I wasn't trial counsel, Judge Boatwright, so I'm not positive, but I think you're correct. I do not think there was a disclosure by him prior to...
Until the employment records
I think that's
came
right.
in. Okay.
That's my understanding.
Well, they subpoenaed the work comp records out of Tallahassee, too.
So he testified to two other work comp injuries in the past, and I think in the course of requesting records from those two, they found the records from the
work comp claim at Amazon.
Correct. So, yeah, I mean, again, we would just underscore...
Prior to that, he had not disclosed anything.
That's correct, Judge Boatwright, at least from my understanding of the record. Again, I wasn't trial counsel, so I'm not positive.
This is always kind of the argument that in any kind of, quote, fraud case, I use that just generically here for the purpose of the discussion. I'm not accusing one way or another. It's always the argument says, well, okay, you got caught in lies here. You can always bring that on cross-examination. At some point, there's a call that's made at the lower court saying, okay, this is too much. It's a punitive event here. You've waived your right to pursue this because of your fraudulent behavior in trying to not present the true facts of the case so that the trier of fact can make a call based on all the admissible evidence. I mean, and so at some point, you know, that side's always going to say, oh my God, look what he did, dismiss it forever. Your side's always going to say, I mean, your side for today. I mean, I'm not saying you're pigeonholed on one side or another. Your side today would say, look, yeah, we all agree what happened. Grill them on cross-examination. If the jury wants to say, hey, pal, just don't buy it, that's the jury call. That's our right under the Constitution or things like that.
I understand. And the judge has discretion, and it's, you know, the law affords the judge the discretion to draw a line in the sand and say, you know, you're out of luck now. We wouldn't be here, I wouldn't be here before you if it wasn't for the unrebutted explanation that's supported by medical records in the record. If the senior center had, you know, cross-examined him, asked him, you know, I don't know, brought in an expert, even called his wife to the stand and said, okay, he's saying that, you know, you have to help him a lot with his day-to-day life, you know, something. But to have an unchallenged, unrebutted explanation that's supported by medical records, I think takes this case out of the line of cases the senior center is depending on, and I think compels a reversal in this case. Unless the court has any other questions, I'll go ahead and reserve.
How's your wife liking her new job?
Liking it just fine. A little less hectic than the, you know, day-to-day rigors of being a trial judge, which I know you know about.
Amen.
Thanks, Your Honor.
All of us do know about that. You know, former trial judges here.
Yep. Okay, Mr. Inclin.
Good afternoon. Clemente Inclin on behalf of the appellee. As your honors have already alluded, some of the issues that are key are this issue about brain issue, of whether or not he had a brain, Mr. Baker had some sort of evidence of brain damage. The records do not show any diagnosis of brain damage. And we can comb through it, we can look at it, and all we see is an EMS record. We may see a record of an ARMP where Mr. Baker may allege or may state something that he has a memory issue. But there's no diagnosis at all whatsoever in any of those records that I'm aware of. I have not seen it. In addition to that, the only medical opinion in the trial record comes from Dr. Romano himself, who says, look, I believe Mr. Baker had a concussion maybe, and that's the kind of thing that would have, within a couple weeks, he would have been back to normal. And therefore, he doesn't suffer from any memory issues, any brain damage, or anything like that. At the hearing, I did ask Mr. Baker a number of questions. I asked him questions to elicit, hey, do you remember that you worked at Amazon? And he said, absolutely. I didn't ask him, sir, do you have a memory issue? What I did ask him was, do you recall working at Amazon? Yes, I do. Do you recall working, signing an application? I remember, yes, I do. In fact, I remember that my wife did it and that I approved it. I asked him about the fact that, well, what were you working? What were you doing there? And those questions were all for the purpose of eliciting what is his memory, which he could remember all these things about Amazon at the hearing, but he couldn't remember it allegedly during the deposition while he was in the process of suing Amazon and still an employee of Amazon. We would submit, Your Honors, that this is a case of clear and convincing evidence. First, that Mr. Baker claimed that he suffered certain injuries, that the discovery, however, that the defense had to go through via countless subpoenas and all the processes that have to go through, were able to find documents that significantly put into question the plaintiff's claim of injuries, if not entirely refute them. But they are these Amazon records certainly really put into question these claims that Mr. Baker has. We believe that the evidence shows that that this was an intentional act on the part of Mr. Baker to not reveal this information.
Well, it has to be for you to have won below.
Well, yes, sir.
I mean, fraud is not, you don't negligently commit fraud. I mean, the judge in essence determined there was fraud on the court, so it was an intentional non-disclosure of critical facts occurring at the time of the deposition. I mean, it's a different scenario that we typically see where you forget that you treated years ago, and then that comes up in a records pickup by insurance defense lawyers.
Yes, sir.
And so, yeah, this is more of a unique case that I'm forgetting something that's going on at the very moment I'm being deposed.
Yes, sir, and that was exactly the next thing I was going to say. It's very unique when you as the counsel are reviewing and you're like, wait a minute, this is what Mr. Baker said in deposition, and then we're putting the pieces together as we move along through the discovery of the case.
Mr. Brownlee wants to know why you took so long to file a motion to dismiss with fraud.
Well, you know, there's in a trial practice, there are many other things that occur in addition to filing a motion to dismiss for fraud, depositions, discovery, mediation, all those type of things that are ordered by the court that were complied with in this case, including discussions between counsel, which occurred for months and months. I would submit to this court that what is clear is that the plaintiff, Mr. Baker, he claims that he had severe, grievous, and permanent injuries, an inability to lead a normal life. Those were his claims in the amended complaint. In his interrogatories, he said that he could not work. He also said that he could not sit, he cannot stand for long periods of time. And in interrogatory number 11, he said that he's seeking damages for past and future pain and suffering. But we see, as Your Honors have already alluded to, in the Amazon records, he claims he has no disability. He claims he can do all of these things that he is claiming that he cannot in his responses to interrogatories. Those responses to interrogatories occurred on January 14th of 2019. His application to Amazon was in May of 2019, just 4 months after the fact. So we see responses saying he can't do something, and we see an application just a few months later saying...
Mr. Brownlee would say that's good stuff for cross-examination. See, you end up getting better there in that period of time. You're no longer complaining by the time you applied for work at Amazon.
Yes, sir, and I think to Your Honor's prior point, I think anything could be offered for cross-examination. He lied at alleged, if he were to lie in front of the court, if he were, sure, anything could be presented to a court on cross-examination in front of the jury. But I think that the system, the judicial system, as the courts state, if you have a system that you rely on having to find the truth through the discovery process, that's a system that's doomed to fail. And there has to be, from the courts, a point where you say, well, how much is how much, where it's clear that the person was not being truthful, where there's...
Well, dismissal with prejudice as a sanction is pretty drastic. Wouldn't you agree?
It's pretty drastic, yes, sir, but it's warranted when in this case you see an individual...
It's warranted in every case where a party is not truthful in discovery?
No, sir. No, not at all. And as a 30-year trial lawyer, impeaching a witness on the stand is part of what we do. But when a witness is not truthful in deposition, when a witness then doesn't tell his life care planner that he has not worked, he doesn't tell his own life care planner these facts, then, interestingly enough, when you look at all the treaters that he was treated for the Amazon injury, he doesn't tell them anything about the Brookdale injury. And interesting, when you look at the Brookdale treaters, Mr. Baker doesn't tell them anything about the Amazon injury. Now, that is if that's not I don't know how one can be that consistent if one has a brain injury where you know who to tell one sort of injury and history, and you tell a whole different set of treaters something completely different. So we see...
Brownlee would say that's why I would put some doctor on the stand to be able to explain that to a jury, and then they could weigh that and determine the extent of his, the explanation as to why he gave you incorrect answers in the deposition. And it's not a forfeit of a jury trial right. It's a thing for the jury to answer.
Yes, sir, and I understand that argument. My only response to that...
I should go down there and sit for him. That's all right. Sounds like I'm being an old appellate lawyer.
Yes, sir, and I understand that. And again, I go back to my point. That argument can be made on the plaintiff's side for anything. No matter how egregious the improprieties of a plaintiff. He
acknowledges that, though. I mean, he basically said if there's no evidence of brain injury, and he's still saying that, then he wouldn't even walking in the door today or something like that. So, yeah, he's saying that. Yeah, but this is the wrinkle here in the case. Why it's for the jury to ferret out, not for some trial judge to make that call.
Yes, sir. Yes, sir.
What's wrong with that argument, or why is that not persuasive today?
Well, because it's the nature of the egregiousness and how clear it is that this person was creating a scheme. I think that's what the cases require the defense to show. I can't really make an argument if somebody just makes a mistake, which happens, sure. A person is inconsistent, it happens. The difference is where the case law sets out that if there's a scheme to try to hide information that will be important for the purposes of adjudicating a case.
That's what he's saying. My guy has this brain injury, so how could he develop this scientian scheme, whatever term that we used back in Cox 100 years ago,
How can he develop that ability to have that scheme if he doesn't have the mental wherewithal to do that because he's been injured?
Yes, sir. And I understand counsel's argument. I would just point back to the fact that there is no diagnosis of that. There's no diagnosis of medical condition, of a brain injury, of memory loss. The only record evidence that the court has is Dr. Romana, the defense CME expert, who says that I interviewed him, I asked him questions, and he at most had a slight concussion after this alleged fall. I would also point out...
When was the fall in relation to the deposition? A couple years?
Yes, sir. Yes, sir. So, yes, sir. The fall was in May of 2018, and the CME was in 2020. So quite some time had passed during that time, including the fact that he had worked. Back to Your Honor's questions before, counsel argues that, well, Mr. Baker, in the underlying case, he is not claiming lost wages or earning capacity, or that he has a shoulder injury. He's not claiming those things. But the fact that he was able to do these things at Amazon go to the heart of the case, and that's our point. Opposing counsel argues in his brief that the trial court did not account for Dr. Romana's interview, and the fact that Dr. Romana apparently had this long conversation with Mr. Baker, that Mr. Baker was allegedly coming forward with information about Amazon. And I would submit to this court that that's not in Dr. Romana's record. All Dr. Romana in his record states is that he evaluated him for a shoulder, he asked him about his shoulder, and that his shoulder was fine. Dr. Romana did not even have the Amazon records at that time to be able to question him about that. Regarding Dr. Lieber, opposing counsel argues concerning what information Dr. Lieber had, and the fact that in his second life care plan, Dr. Lieber at that point did have records concerning the injury. But what Dr. Lieber did not have is the Amazon records. He did not have the Amazon records to be able to compare what Mr. Baker was actually able to do versus what he was in his initial life care plan indicating that he couldn't do. He couldn't do 80% of housework. He couldn't do 50% of this. He couldn't do 40% of that. If Dr. Lieber had had those Amazon records, he could have seen that that's very inconsistent, and Dr. Lieber never had the Amazon records. And he also did not interview Mr. Baker in the for the second life care plan. And I'll start wrapping it up here. In terms of the memory loss issue, I would just point out that the point that he consistently omitted information, and he selected who he gave information to, versus the treating doctors, not only Dr. Lieber, but the treating doctors from the Amazon care and the Brookdale care. I would point out further that in the underlying evidentiary hearing, I never did concede that there was a brain injury. The only thing I said in the record was that the plaintiff alleges that there was.
What facts do you think could be added to the record that would suggest that there was an abuse of discretion here? I mean, you're arguing that we all agree, counsel agrees, it's an abuse of discretion, this heightened abuse of discretion standard that people talk about. I think I actually talked about it in an opinion. I'm not sure why, but so your position today is please affirm it because there's no abuse of discretion based on the record here. What do you think? What else? Where would you think the trial court would have abused of discretion? What other factor in this case could have been added that would suggest it's abuse of discretion on your part? Just trying to get the kind of a feel about this heightened abuse of discretion standard, even though I wrote about it.
Yes, sir. And I'm not.
What did I mean when I wrote that?
Respectfully, I'm not sure that I'm understanding Your Honor's question.
Well, in other words, you're saying this is not an abuse of, at some point there is an abuse of discretion in a setting like this. What do you think what else would have had to happen here below If the judge still said, you're still out, the case over, you're dismissed with prejudice, what other facts could have been in the record that the judge ignored that we would look at as abuse of discretion?
Well, if I understand you, Your Honor, correctly, I mean, I think it would have been abuse of discretion if we didn't have an evidentiary hearing, if Mr. Baker had not given an opportunity to present at the hearing, which he did.
What if a medical doctor came in and said, of course, this guy has clear memory loss and difficulties, and it's certainly explainable why he may have been working at the time he was deposed and he couldn't remember that, and here's the medical or psychiatric explanation for that doctor, and then they have 3 doctors who say that, and the trial judge says, I know better, I am the credibility weigher, I reject all of that. Would that be abuse of discretion for us to not, an abuse of discretion for the trial judge to have still dismissed with prejudice?
Given that's an interesting, it's an interesting hypothetical, and I think I would respond to that, Your Honor, by saying that the life care plan, if we look at the life care plan, it probably has 30 pages of a medical chronology of different providers that Mr. Baker went to. He went to neuro, he went to back, he went to pain, he went to everything.
Well, I mean, I know I sound like I'm saying a little bit tongue-in-cheek here, but pragmatically, we write these wise things theoretically up here, but it still goes back to you guys and to trial courts to say, okay, well, how does that actually apply when you write these nice legal principles here? What does that actually mean in real world when you guys are presenting evidence and a trial judge is listing evidence and having to make these rulings? So, it's kind of, this is too much, or in this scenario, this might be enough to be abuse of discretion if you listen to that and still dismiss it. That's kind of the whole purpose of my hypothetical. I sound like an old law professor at the University of Florida here that shall remain nameless. Maybe actually deceased too, but go ahead.
Yeah, I think my response on that, Your Honor, is you have to look is there a scheme and the extent of the scheme. When he was given an opportunity in the update interrogatories, which were months later, he could have cleared this up, and he didn't.
So if Mr. Brownlee's trial counsel had put on evidence that said, Judge, I know what the law is here, this is no schemer. He doesn't have the wherewithal to scheme. He just has this brain injury, he has CT, whatever he has. I'm not trying to, impact your Mr. Baker with illnesses that he hopefully will never have, but that's the guidance. We should be giving guidance when we write stuff here. At least that's my view of some things here. It might not be the view shared by others, and that's their prerogative. But
well, perhaps this might be helpful. If we look at his pleadings, plaintiff doesn't claim memory loss or brain damage, and he doesn't do so in his interrogatories, in his responses. In his own deposition, he doesn't claim it.
So if he had done that all the way along before he was made these answers in his deposition, then that would be factors that would benefit Mr. Brownlee's side.
I think it would be considered. I mean, I think there are some cases that the courts is very aware that it's very easy for a plaintiff just to say, well, look, I think I must have some sort of memory loss. And just coming in at the last minute and saying I have some memory loss, or at any point arguing memory loss, doesn't in and of itself is not sufficient. And here what the clear record is that we don't have a diagnosis of memory loss. We don't have a diagnosis of a cognitive deficit. And in all the years that the case was going forward, and the time that I guess I didn't bring up the motion to dismiss for fraud, there was certainly the opportunity to have an expert, like you suggest, Your Honor, and that was not presented, and that's not part of the record. So we're left with what the record is in this case. And again, if the plaintiff was claiming this, one would think that it would be in the complaint or in the interrogatories, in the updated interrogatories, or something pled that says there's brain loss, memory issues, and there's not. At any rate, I thank you for your questions. We believe that the trial court had an opportunity to see Mr. Baker, question Mr. Baker. In the deposition, he is in a unique position as a trial court to do that. And for those reasons and all the other reasons that we stated in our brief, we believe that under an abuse of discretion standard, the trial court's order should be upheld. Do you have any questions for me?
think we're good.
I think we're good.
Thank you very much.
Thank you, sir.
May it please the court. I'll be brief. I know this is your last of many oral arguments today. Your Honors, the reason everyone is cherry picking from these records, right? They're saying there are some records that show that he doesn't have brain damage. Again, I would pointed you to two specific places in the record for 2 years after his deposition, pages 1352 and 1354, where he's being treated for decreased memory and retention and for struggling with cognition. So there's some records that support our allegation that he has brain problems that affect his memory. There are some records that support theirs. But it is their burden to put on clear and convincing evidence to take away Mr. Baker's constitutional right to a jury trial. They failed to do so. That's why we're sitting here talking about, both sides are cherry picking, for lack of a better term, stuff that's helpful for them and supports their respective positions.
But I mean, isn't there some threshold at some point to say, oh, okay, you may have some, you have some brain scenario, brain injury, or whatever the term was being used, but that doesn't mean you remember. It seemed like for a trial judge would be within his or her right to say, hey, look, okay, I get that, I hear that, but I don't understand how can you forget something that you're doing right that same day. And I don't have enough other than that to suggest that what you are telling me that you have, or what I'm reading in these medical records, gives me enough of an explanation to justify why you have flat out told an untruth to the question, and therefore I don't buy that what your brain condition is causes this. That only leads me to the other conclusion. You're intentionally trying not to let me know about, or let the other side know about, a real salient factor here. Your ability to do a lot of things, your ability to enjoy life has not been impacted, therefore you've crossed the line. I mean, that's kind of where...
I understand. And I think, again, if in the absence of medical records that support his claim, and the absence of even a single question on cross-examination, right? I mean, this is how this should have worked, at least as I see it. Okay, Mr. Baker says, I have memory problems, I have cognition problems. There's a question that says, okay, do you really? How come? Where is that shown in your medical records? At that point, Mr. Baker's lawyer can say, well, here it is, the places I'm pointing you to in the record right now. Here's the medical records that support his explanation. None of this stuff is fleshed out. And that's the issue from my perspective, is it's a failure of proof. There's not clear and convincing evidence of a perpetrated scheme to defraud when there's not even a single question asked to challenge Mr. Baker's explanation. And if this court believes that, on those facts, a trial court with this heightened abuse of discretion has, it's within its purview to say, I just simply don't believe you, okay, then we lose. I get it, but I don't think that that's how it's supposed to work. I think if he gives an explanation, it's not challenged, there's not a question asked about it, and there is support in the record that supports his explanation, that's not clear and convincing evidence. It's simply not carrying a burden of proof. So, in the absence of any other questions, I'm going to sit down.
All right.
Thank you, Your Honor.
both
Appreciate
very
it.
much. Well briefed and well argued.
So we're going to stand adjourned?
We are adjourned. So the magic words.
Back when you all ignored me as a chief judge, I thought we were getting little clocks
Yeah.
for all of us here. So I can't read Harris's clock anymore. He's in there. Whatever happened to that?
We're utilizing those for the travel always now. Or no,
Yeah, the little clocks so that we can see what the clock's going here. 'Cause I
we
can't.
had those up there in the past?
No, we got that thing that but I mean over here, if we want to say,
We'll get some more.
we got some? The little clock.
Yeah, the little clock.
All right, man. Well, hey, it's nice to meet you in person.
Nice to meet you, man. Hey, pleasure to meet you.
If I have any appeals today, I'll make sure I give you a call.
Hey, okay, just don't do a background check. Hey, good to meet you. See you. Good luck to your son, too.
Take care, have a good one. They haven't had their own
I thought that there really wasn't a need to have them on the attorney's tables.
Right.
And we could take those and put those up there.
Yeah, yeah,
Because
absolutely.
they have a clock right there.
But
Yeah, okay, all right. I misspoke.